Okay, I think we're going to get going. People can kind of join us whenever, but it seems like there's quite a few of you in here already. So thank you all for coming today. So today we're going to be talking about the Endangered Species Act in practice, federal and state dynamics, and AB 1319 with my guest speaker here. Um, just to go over, I'm going to do a quick introduction of my guest here. She's going to do her presentation, and then we'll do a Q&A at the end. If you guys have questions as it's going along and you want to put them in the chat so you don't forget about it, please feel free to do that, and then I'll go through and go through them at the end. At the end, I should also be able to allow you guys to speak if you'd prefer to ask your question that way. Okay? All right, so joining me today is our amazing guest speaker, Kim Delfino. Kim is an environmental policy advocate, attorney, as well as president and founder of Earth Advocacy. In addition to all of that, she is also one of our amazing professors who teaches in our MSL and LLM online programs here at McGeorge School of Law. So thank you so much, Kim, for joining us today. All
Thank you.
right,
I'm happy to do it.
with that, I'm just going to hand it over and let you get started.
Great. All right. So I'm here to talk about the intersection of the State and Federal Endangered Species Act and a bill that was just passed last year. I'm going to sort of set the stage. California is a global biodiversity hotspot. It's only one of 36 in the world. As an example, we are home to around 6,500 unique flowering plant species alone, 1,200 of which you can find only in California. And the reason for this high rate of endemism, which is you can only find them in California, is it attributed because we as a state have very diverse climates and habitats. And you can also see animal species like California condor and desert tortoise, and they further underscore the importance of California's wildlife. Next slide. California's biodiversity is protected by actually a number of state and federal laws, but the ones that get the most attention are the state and federal Endangered Species Acts. And these are, to some extent, laws that protect and conserve our most imperiled species, the ones that are most likely to go extinct given current conditions. The two laws operate independently, but are also intertwined. Together, they serve as a safety net for 180 animals. And when I say animals, I mean fish, amphibians, reptiles, birds, mammals, and vertebrates, and also 290 plant species. And of that list, 80 of the animal species and 65 of the plant species are only protected under the Federal Endangered Species Act. The rest are being protected either under the State Endangered Species Act, which is the California Endangered Species Act, and I'll refer to it as CESA, or under both the federal and state acts. Some of the species that are only protected under the federal act are various runs of steelhead salmon, California's spotted owl, the Pacific pocket mouse, and the California gnatcatcher. Next slide. The Federal and State Endangered Species Act are very similar in some ways, but also different, have some important distinctions. Both the acts require that findings are made to determine if a species should be put on the respective lists. Under the State Endangered Species Act, or CESA, the Fish and Game Commission is the entity that makes the final decision, with significant input by the Department of Fish and Wildlife, or CDFW, and also with a public process. Under the Federal Endangered Species Act, the federal agencies, either the U.S. Fish and Wildlife Service or NOAA Fisheries, make that decision. It is not a body like the Fish and Game Commission. The Fish and Game Commission, by the way, is 5 people that are appointed by the governor. So it's slightly different. The criteria, though, for putting a species on the federal or state endangered species list are very similar. So you look at habitat loss, disease, predation, overutilization, which tends to be like hunting or utilizing it for some product, inadequate protections, and other factors. Once a species is placed on either the federal or state endangered species list, there is a requirement that you cannot take or kill a species without a permit or authorization. Next slide. Oh, no, that's the right slide. Don't change it. There are some important distinctions between the state and the Federal Endangered Species Act. And I'm going to talk about these because this is important when you think about what gave rise to Assembly Bill 1319. So, under the State Endangered Species Act, when a species so what happens is you petition to list a species. Either an individual can do that, or the department itself, or can nominate a species to be put on the list. There's a two-step process that happens. And this is both for the federal and state. First, they make a determination whether listing may be warranted. And if that happens, the species becomes a candidate. And then they make another determination later, based on science, whether or not listing is warranted. Under the State Endangered Species Act, when a species is a candidate, meaning it's made that first determination, but not the second, it gets full protections of the State Endangered Species Act. Under the Federal Endangered Species Act, the species does not get full protection until you clear that final hurdle of is warranted. Also, under California, you can list a species under our state law if the species is rare in the state, even if it's numerous outside the state. So an example here is burrowing owl is currently a candidate for listing, under our State Endangered Species Act. It is declining severely in the state of California, yet it is numerous in other states. Another important distinction is that the Federal Endangered Species Act does a lot more towards identifying and protecting habitat. So under the Federal Endangered Species Act, there's a provision that allows the agencies to identify what is considered critical habitat. So habitat that's critical to the continued existence of the species. And I won't go into the details, but there's a lot of back and forth about, should it be habitat that's already occupied? Should it be habitat that previously was occupied? Should it be habitat that isn't occupied now, but with climate change, we can project that the species will be moving into that area. But needless to say, there's an emphasis on habitat under the Federal Endangered Species Act. Under the State Endangered Species Act, we don't have any type of equivalent of a critical habitat designation. Likewise, the State Endangered Species Act has a narrow definition of what's considered take. So remember I said that once a species is listed, there is a prohibition on taking that species. Under both acts, you cannot purposefully kill a threatened or endangered species, but you can indirectly take a species. So if, for example, while you can't shoot a spotted owl, you could destroy habitat associated with that spotted owl. But where the distinction is in that sort of spectrum between the state and the federal act, it goes back to habitat, which is under the State Endangered Species Act, we have sort of a narrower, tighter through line between when the action taken, like habitat destruction, and the death of the listed species. We call that causation. And under the federal act, it's a little looser in the sense of you don't have to necessarily show that the habitat destruction will result in the immediate death of a species, understanding that biology is complicated. This was upheld. So the definition, it's called the harm definition. And this rule that the federal was promulgated under the Federal Endangered Species Act was actually upheld by the U.S. Supreme Court in a seminal U.S. Court decision called Babbitt versus Sweet Home. This becomes relevant in a little bit. I'll talk about why this is a big controversy. But in that, habitat destruction was defined as part of harm and therefore triggers the need to get a permit or an authorization for a project. And then also under the State Endangered Species Act, we have a fully mitigated standard. So in order to be authorized to allow the take of a species, you have to fully mitigate for the impacts of your project. Whereas under the Federal Endangered Species Act, generally speaking, the standard is mitigate to the maximum extent practicable. So it's not quite as strong as the state act. And then also, which is greatly pains me, but our State Endangered Species Act does not require recovery planning or recovery action, and we don't fund it. I think that's a great weakness in our state efforts, because I think that we don't just have to list species to stop extinction. We should be proactively trying to get them off the list and recover them. But That is a difference. So together, the state and the Federal Endangered Species Act have a coexisted well as a safety net for threatened and endangered species. However, under this current federal administration in Congress, we are seeing unprecedented, likely rollbacks of bedrock protection standards that we have long relied upon. Next slide. So, the current federal administration has made it clear that it intends to weaken protections for biodiversity, particularly for threatened and endangered species. And since January of last year, President Trump has issued multiple executive orders with directives to weaken protections for federally listed species, including mandating quarterly meetings of the Endangered Species Committee, which is colloquially referred to as the God Squad. And the God Squad, which has only been invoked, I think, 3 times, is essentially a group of people that can come together and say, hey, even though a project is going to cause the extinction of a species, it's so important that we're going to allow it to move forward and override that prohibition on take and extinction. I would also point out that the Trump administration is not alone, that there are more than 100 pieces of legislation pending in Congress today that would amend the Federal Endangered Species Act. In April of 2025, the Trump administration also released a proposed rule to cut back endangered species protection on that harm definition. So remember, I talked about how there was this through line between habitat destruction resulting in impacts to a species, and that under the federal act, harm includes habitat destruction. So what the federal administration is proposing is to eliminate habitat destruction as a trigger for requiring a permit to take a species, meaning that you have to show that you're going to cause the death of a species. And let me give you an example. So under the current definition of harm under the federal act, if you have a tree with a nest in it, you have to get a permit to be able to cut down that tree if it's an endangered species nest. Even if the species is not in that nest at that time and there's no eggs in that nest, because for many species, they come back year after year to this nest. And this definition recognizes that while a species may not be immediately present, that particular place that we're talking about is important to the overall biology of that species and the continuing existence of the species. Under the Trump administration definition, if it's adopted, which we expect that it will, because they've already closed out the rulemaking process, and we're expecting to see this come out shortly. If the nest is abandoned, there's no bird or egg in there, you can cut the tree down. So the only time you would have to get a permit is if there's an egg or birds in the nest. It's kind of an extreme example, but the point of it is that it very much narrows down habitat protections under the Federal Endangered Species Act. So with this new definition of harm moving forward, organizations who work on endangered species issues were very concerned that there would then be a flood of petitions of these 145 species that I talked about that are only federally protected in California, that suddenly the Fish and Game Commission was going to get a bunch of petitions to list these species due to the weakening of the standards of the Federal Endangered Species Act. And we were very worried that they would be overwhelmed. And we were also worried that a number of longstanding conservation plans would also be weakened or destabilized by losing that federal protection of habitat. So given these concerns, Assemblymember Nick Schultz, who's from Los Angeles, he took the seat that Laura Friedman, who's now in Congress, he took her seat. He introduced a bill, Assembly Bill 1319, to beef up protections for federally listed species. And Defenders of Wildlife was a sponsor of the bill. And AB 1319 did 2 things. I'm going to really just focus on the one part that was the controversial part, but I will acknowledge there was a second part to the bill. And that second part of the bill strengthened laws around the illegal importation or export of fish and wildlife. So in addition to worrying about habitat protections and projects that are moving forward that are impacting endangered and threatened species, another part of protecting biodiversity is protecting against the illegal importation or exportation of species parts. So, for example, ivory being imported into California or shark fins, or believe it or not, I guess there's a very robust pangolin market that's driving the extinction of the species. So this one portion of the bill beefed that up, gave CDFW more law enforcement ability, some improvements for wardens to do tracking of and prosecutions of these types of illegal activities. But the part of the bill and that was non-controversial. The part of the bill that was controversial was the part that created this, what I would say is a cost-effective, science-based provisional listing process to protect endangered and threatened, federally endangered and threatened species that were left unprotected by, quote, decreases in federal protections. So while normally a listing process will go through the Fish and Game Commission, AB 1319 sets up a temporary provisional process in which the Department of Fish and Wildlife can look at rule changes or changes by the federal administration or Congress to endangered species protections and decide that the action would substantially decrease the protections for those federal species, and they could provisionally list those species on the provisional endangered species list, and then they would get full protections of the State Endangered Species Act. Now, I just want to walk through just a few specific components that I think are important. So, what is a decrease in federal protection? So the bill defined that it is a two-part step. First, you have to ask, what is the federal action? And a federal action would be whether or not the Federal Endangered Species Act is amended or repealed, whether or not federal regulations implementing the Endangered Species Act are amended or repealed, whether there's an executive order decreasing protections for endangered species, or whether the God Squad has been convened to allow an action that would cause extinction. So only those four things would trigger Assembly Bill 1319's provisional listing. Once one of those four actions are taken, then the Department of Fish and Wildlife must find that the federal action reduces protections by either delisting, taking a species off the list, downlisting, taking an endangered species down to a threatened species, and changing the rules on killing a species, which is the harm definition, or reducing the amount of mitigation that was previously required for a species. And so, it's not, I think some folks were saying like, hey, this is going to be like willy-nilly species going on the list, but there has to be a very specific action taken and a specific outcome to that species in order to trigger this. So, uh, so really the intent of this bill is to focus on those species whose continued existence really is in trouble due to the federal action. So some folks have argued, well, if you put this species, CDFW, the department could abuse this process and maybe put a species on the list, under the provisional list that was removed from the list by the federal government because it was recovered. In order to answer that argument, we made it clear that any party can petition the commission to remove a species from the provisional list using the existing delisting process. So if a party disagrees with an action taken by the Department of Fish and Wildlife, they can move forward with a delisting process through the regular delisting regulations that we have out there. Also, as part of answering some of the concerns that were raised, there were parties that said, well, hey, we already have a Federal Endangered Species Act take permit. And if you list these species that were only federally listed, now we're going to have to go get a new state permit. And so to address that concern, the bill was amended to allow parties who have pre-existing federal permits to utilize those federal permits in lieu of a state permit. So there isn't a need to get a new state permit as long as your permit was enacted before January of 2024 was issued, and as long as you haven't made any changes to that permit subsequent to January of 2025. So this was an effort to try to lessen the burden on people that have already done what they thought was the right thing to do and get their permits, and also lessen the burden on the Department of Fish and Wildlife to have to go through the process of issuing new permits to folks that already have federal permits. So that was, I think, an effort to try to, again, make this a really very focused and streamlined permit process. So Governor Newsom signed AB 1319 into law in October. It went into effect this year on January 1st. And in recognition of the strong likelihood that we will see federal actions taken to reduce endangered species protections, the administration has proposed in this year's budget proposal for the 2026-27 budget, which we're just sort of starting that process of putting that budget together in the legislature. They've proposed what we call a budget change proposal, asking for 5 new staff to be able to track this process at the federal level and to process and work through the provisional listing process in anticipation of what we expect will be some fairly widespread rollbacks of federal endangered species protection. So if that does get approved by the legislature in June, end of June, that's when the budget has to be finished, then starting in July 1 of 2026 of this year, and then moving into the next budget cycle, the department could start hiring staff to work through these endangered species issues. I'll flag this because I think that whenever you're working on on any type of legislation where you're making changes and you're asking for new responsibilities and duties being put on agencies, you have to be cognizant of the fact that when you're doing that, you're putting on a responsibility that adds more workload. So you should be supportive of trying to fund the new workload that you just put on that agency. And so organizations will be supporting that proposal by the administration to staff up. I would just close by saying that we hope that we never have to use AB 1319 because if we don't use 1319, that means we've not weakened the underlying safety net of the Federal Endangered Species Act. But in the event that that does happen, fortunately, California has stepped up and is prepared to protect its declining biodiversity.
Thank you, Kim. All right, guys, I'm going to open it up for questions. So this is just if you're interested in applying to our programs. These are the deadlines for the fall 2026 semester. That's both for the LLM online and the MSL as well. For the MSL online in water and environmental law that Professor Delfino teaches in. So if you guys have questions, there's a Q&A, you can pop it in. You can also raise your hand and I can allow you to talk. So just let me know. We'll give you guys a minute or so to get some questions in there. And while we're waiting, I just wanted to ask Professor Delfino, so when new things like this pop up, do you kind of alter your courses or add in like discussion posts and things like that so that students get exposure to like what's really going on in the class in the world?
Yeah, actually, so I revamped the course this year and added a lot more, added more state efforts. So it's now, the previous course was very federally focused, and now we've added in some state issues. And actually, 1319 is discussed in the, actually, we have a whole module now on the State Endangered Species Act. And so I added in 1319. We actually, in the toxic section, talk about the plastics bill, SB 54, and the debates around that, talk about some of the PFAS issues that are going on. So very much trying to incorporate the current debates that are happening within the different issue areas. When we talk about the Clean Air Act, we're not just talking about the federal Clean Air Act, but we also talk about state the state implementation planning, but also the waivers that California is sort of at the leader in terms of doing zero emission vehicles, clean car fleets. So we talk about all of that. So I would say for better or for worse, the area of environmental law is incredibly fluid at the moment. So many changes that are occurring, kind of, it's almost like a whiplash, with the different administrations that are coming and going. But also very exciting because California very much steps in and like regulates as well, where there's gaps left by the federal government, but also in coordination with the federal government. And so, yeah, I try to be as responsive as possible. And then actually, what I also do is that as the course is going on, when things happen, I'll post in I'll put in updates and let people know, like, hey, they just, issued this thing about the National Environmental Policy Act, or hey, there was a Supreme Court decision that the oral argument just happened, and here's a summary of that and a link to that, because I think it's really good to understand, like, the world that you're operating within and all the different complexities as you're learning the law and the policy. So that's the other thing we do is we talk a lot about the policy part of this. It's like, what are the policies? Why are the policies being put together? What are all the different pressure points associated with the policies, costs, affordability? I mean, all of the different things that, we're debating now in the state legislature and in Congress. I try to weave that into the different modules.
Awesome, thank you. Okay, so we do have a question. Can the state law be sustained in court if federally challenged? Will federal law trump the state law?
So it's a good question. Under the way that so states actually have they are the managers of public trust resources like fish and wildlife. So there's no problem with running afoul of like the supremacy clause or some of the other times where state laws have been found to go over and above, because we've basically just this is where the federal government has backed away from their regulation and the state has stepped in to fill the gap left by the federal regulation. If the federal government was regulating and then the state steps in, then that does raise issues about supremacy. But in this case, it does not.
All right, any other questions, guys? Just gonna give you another minute or two, and then if there's no other questions, we'll let you guys go.
Well, I hope this was helpful. I hope people found it interesting.
I mean,
Um,
I certainly did. So
yeah. Yeah, and this one on this AB 1319, I mean, California is the first state to step into the gap, and is incredibly prepared. Oh, we got a couple more questions, looks like.
oh, yeah. Are there similar efforts with the air quality?
Um, that's a harder one, honestly, because the Clean Air Act, the Federal Clean Air Act, is so all-encompassing. There, it's more an issue of operating within the confines and construct of the Federal Clean Air Act. There's not as much of a gap. With that being said, under greenhouse gas emissions, I would very much say that the state has stepped in and done a lot more regulation of greenhouse gas emissions as an air quality issue than under the federal government. Again, where there's a gap that's left, then the state's able to operate a little more. But if you have a really encompassing project law, then I think you have an issue. Now, the other place to look at is the Clean Water Act. So under the Clean Water Act, there's a whole contraction of the scope of the Clean Water Act under the definition of waters of the United States. So before we had a much broader range of a definition of what a water of the United States is. And in that case, then the federal Clean Water Act would regulate, and then the state through Port of Cologne like tried to mesh in with that. But now that the Supreme Court has ruled that we need to narrow the definition of the Clean Water Act, and the Trump administration is putting forward a proposal that significantly narrows what that definition is so that it doesn't cover what we call intermittent and ephemeral waters, which is a lot of the waters in the United States and the Western United States. That then leaves a gap because suddenly the federal Clean Water Act no longer covers that chunk of waters. And Porter Cologne will step in, which is our state Clean Water Act, and we'll start regulating that. And that again doesn't trigger supremacy clause or any of those issues because again, it's where the federal government is pulled back and you have the state stepping in. And we've seen this with the state in 2019 implementing the state wetlands policy. And now there's legislation currently pending that I'm working on with Defenders of Wildlife, called Senate Bill 601, which is trying to fill the gap that we call is left by the Sackett decision by the Supreme Court. So again, very active area here in trying to fill in gaps left by federal contraction of laws.
Okay, so rest are just saying thank you and very
Oh,
informative. So,
well,
but
you're
all
welcome.
right. Okay, one more minute just because there's quite a few still hanging out. Sorry if you heard that. But other than that, if you guys are good, you can sign off. I will be sending out a follow-up email if you have any questions and want to reach out later. Please do let us know. Great, I'm not seeing any more questions coming in.
Oh, we get a
Will
copy
we
of the
be able
slides.
to?
Mary, if you
Um,
don't get them from them, I can send you copies of the slides.
I should be, I can definitely send you copies of the slides. We'll also probably be sending out a recording of the webinar. So yeah, I will make a note to do that. Probably by end of the week, I'll be able to get that to you.
Cool. Nice to
All
see you,
right.
Mary. All
All right,
right.
guys. Well, thank you so much for joining us. And Professor Delfino, thank you so much for your presentation and your just information on all of this.
Cool. Glad to be
All
helpful.
right.
All right.
Have a great day, everybody.
All right. Bye-bye.